Hi, ladies and gentlemen. Welcome. Good to see you here this late in the evening. Appreciate the enthusiasm. Let's see if our topic and panel can do justice to your endurance brilliantly. So let's keep this conversational. We'd really like to have some questions, your participation from the outset. There is nothing to prevent you from like putting up your hand, asking a question. Is that how it works? Can they just ask questions? Yeah, they can just ask. You can ask questions. No question is too basic, so don't feel intimidated about data privacy and such. Our panel has already been introduced. We are talking about a new piece of law. We call it the Personal PDPA, Personal Data Privacy Act, correct? Right, so we'll use this acronym. It's PDPA. If you heard of GDPR in Europe, when you visit websites, sometimes you come across this, come across this notice asking you to give the website permission to collect some of your personal data and use it for specified purposes. So PDPA is potentially similar, but we'll ask the experts. I think Jayanta was involved from the outset in framing and drafting this legislation, Jayanta. Jayanta, let's start with you. Can you outline for us what the purpose of PDPA was? Let's keep it very basic. Let's drop all the jargon, and if you were explaining this to a 10-year-old, how do you explain PDPA?
Yeah, thank you, Shamindra, and thanks to the organizing committee of this event for putting this subject as an area of discussion this evening. Outlining a subject like this to a non-legal audience has always been a challenge for somebody like me, and in fact, Sujit might do better justice than me. But to put it simply, this new law is a framework to regulate something called processing of personal data. So regulating processing of personal data means, in layman's terms, how do we ensure proper governance and management of processes involving our individual data sets, right? So our personal data sets would mean any kind of telephone number, email address, location data, or any identifier connecting us, and how those identifiers will be processed. When it comes to a bank, telco, or any digital platform, we are using all the digital platforms nowadays, even during COVID or post-COVID, to buy products, goods, and secure services for our day-to-day functions. In all those activities, we provide our personal information, including our mobile number, to our address, to sometimes our ID card number. Even if you go to a school, we all know as kids how our parents would admit us. The parents would give their personal details to the school principal, and all our kids' details, including the original birth certificate, will be in the school. In future, when this law comes in, if you look at a school environment or a digital platform or a bank or a telco, all those entities will be regulated under this act within the framework of what we call a control and a processor. So the school principal or the ministry, all those will be governed through a layered process. under this law.
So you're talking about a controller and a processor for this data. John, it's just some basic stuff, right? This act regulates all data. It doesn't have to be in digital form. It can be something you submitted to your school 20 years ago, 40 years ago, and still will come under this act?
Good question. Yes, because I would qualify your statement by saying not all data, personal data, which is defined to mean identifiers and other connected activity linking somebody called a data subject. And a data subject is not a corporate entity, an individual. So we are talking of individual rights, not only those who are living, Shamendra, but those who have died, including our kids, whose rights will be protected here if they are under 16, where parental consent, etc., will kick in to process that information.
So what we are attempting to understand, and I suppose we have a largely business audience and some school children also with us, so great to have you here. But a largely business audience, what we are trying to understand is the impact this law, data privacy, will have on digital services in Sri Lanka. Jasmine, I'll come to you. You're in KL, can you give us some background on how you think, a viewpoint on how personal data protection is managed in the region, particularly with reference to Malaysia, probably?
Thank you so much. I would like to build on what Dr. Jayant said, and it's interesting that personal data protection laws has come in different permutations, right? But GDPR became that gold standard, and then we looked at how the APEC CBPR, cross-border privacy laws, started flowing through, and what today has become a common practice across the region is that the laws, whether it is Malaysia, Singapore, Indonesia, Thailand, what we see is that if a personal data needs to leave your borders, it's very interesting. It says that the law that the regime, the legal regime of the receiving country has to be at the same level or better. And this is to safeguard. Cross-border data flow is inevitable because of how digital economy works. And therefore, what we have seen is in order for governments to attract the right kind of investments, we talked about digital nomad before this, the right kind of digital economy to flourish, governments are building, a lot of the personal data protection laws become that attractive pivot to ensure that the right kind of investment comes into countries so that they see that the laws can, the data can flow between the regional markets to ensure that personal data is protected, but at the same time, it becomes that competitive differentiator. If I may, I'm going to show one of the ways that we see, if I may, I'll just share my screen. So this is the World Bank Government Maturity Index. Let me congratulate Sri Lanka on being in Group B in this movement of, from analog to e-gov, to digital gov, to GovTech, where we see that citizen services is moving away from digital government to GovTech, and this is the movement, right? And this is where personal data become integral to what the speaker before me said, how you go to a school and now you need to register the child and you give all of the personally identifiable information, the PII, and citizen services become intrinsically and digital by default, and GovTech is now focusing on that, and we see that personal PDPA, personal data protection laws across the region also serves this GovTech element. So I just want to pause there and say there are two ways. One, for digital economy. Two, to serve better the citizens. That's where I will pause Back to you.
Right. Sujit, I'll come to you. Jasmine already touched on this fact also, the potential that personal data protection laws can have towards investment, right? Particularly in digital services. Can you outline for us what that opportunity is? Is this something that will stand in good stead for Sri Lanka as far as investments in digital services are concerned? One might look at it and say, this looks really cumbersome, versus what we were used to in the past. How do you see that?
Shamindra, thank you so much for the question, and thank you very much for having me as part of this panel. I would actually take the last word you used, cumbersome. Right? So especially when we talk about security or even privacy, it is going to become cumbersome because people are used to doing things in a specific manner. So that means culturally, our habits have to change, the way we operate. I think we are increasingly seeing demands from the data subjects, when I say data subject as in individuals, wanting to have the right in the manner the data will be collected and used. We are not only seeing this in other parts of the world, it is increasingly gaining traction in Sri Lanka as well. Right? At least people living in this part of the city are at least asking. So the challenge I see is how do we get everybody on the same plane as we are in Colombo, especially people who are remote places, government employees, the way they handle information, all that has to happen. So it's definitely an opportunity for us to transform the people's mindset and the way they work. One. The third aspect I would like to mention is, the recent times we are seeing a lot of breaches in other parts of the world, right? One, we saw a case in Finland where one of the clinics which were actually dealing with medical health records, patient records, they were breached. And the people are now concerned as to who would actually have access to that information and how that information will be used. Now, I remember reading a case where this individual had actually gone for counseling for depression. So he starts with saying, he didn't want anybody to know that he actually consulted a psychiatrist for his depression. But then he also goes on to say that he doesn't want his mother to know that he was addicted to drugs. So you're talking about a patient history here. And one last thing, right? We also saw in recent times an Australian case. The insurance company in Australia, the private insurer, Medibank. So many records have been breached. Now, here the attackers have access to person's personal data, and as Jayanta mentioned, we are also looking at the related information, right? So we are talking about diagnostics reports, or procedures. All these information are going to be there. Now, one example I would like to quote here. Imagine what actually could be going through a mind of a person who has gone through an abortion, right? It might have been a natural cause, or it could have been otherwise. Now, this is very personal, right? Now, this particular information, when the attacker has it, he could always reach out to that person and say, hey guys, if you don't pay up, you're going to disclose this information. So one, it's a good thing that we are now bringing in a good governance in terms of how we manage data. And more importantly, for you to adopt digital services, you need to create that trust in the way how technology is going to be used. Shamindra?
Right. So Sujit mentioned data subjects, right? So everybody here is a data subject, potentially. So this is a piece of legislation that gives you a level of, it gives you rights over your personal data held by other people, right? And also we discussed two things here. Sujit discussed several things, but one of which was security. It's a cumbersome thing. Privacy also tends to be cumbersome, right? So let's see if anybody has questions. Anybody wants to put questions to the panel? We can do this from the outset, right? We have 30 minutes more to go. Right. We'll so the floor is open. You just put your hand up. We'd really love to have some questions. I'm coming back to you, Jayant, about the business case, right? And if you address an audience that are tech companies, that are potentially SMEs in technology, right? What new demands will they have to be practically thinking about? I'll come to you and Jasmine also with the same question, Jasmine, right? I mean, let's think about a tech company that's, that's not really broken into the big leagues yet. They've been used to managing data, personal data, fairly, without much, potentially they're concerned about security, but not necessarily about privacy. What new demands does this bring and where do you start? If you're a company with a lot of digital data, where do you start? I think it's on this.
Yeah, so interesting question, because the more I think of it, sometimes the more scared I get. Not about the big companies, but the smaller ones.
Smaller guys. So if anybody is feeling overwhelmed, they're not alone, you know.
Not alone.
Right.
And exactly. So I had to mention this in the context of important aspect we need to keep in mind when we look at this new law. It was not drafted in isolation by a group of people together. It was a public-private community of people working on it, and you know some of them well. It's important that we understand it was also not drafted in a closed-door setting. So we have some of our old friends here who were involved in the public consultation process, the Computer Society of Sri Lanka, FITIS, Ceylon Chamber, all of them had extensive discussions, and we heard from the SME and the smaller companies the challenge they have on the basics they need to follow to protect personal data. Because remember, Shamendra, when we look at data subjects, it's not only the people in the room or people in the country. You're talking of data subjects. It's not limited to the citizens here. Even those who are visiting, including the digital nomads or tourists who come in here, can claim protection here. And that is where the interoperability between this and other parts of the world comes in. So in order to have your rights protected properly, to ensure the governance here, smaller, bigger entities might have to look at some basic housekeeping aspects. So in terms of housekeeping, what needs to be done is explained under Section 12, what we call the Data Protection Management Program. That is an in-house method to basically manage and provide for any mechanisms to even obtain and respond to a complainant. Finally, I'm not going to talk of the security and other practical aspects that Sujit would cover, that a SME or a small business can look at in terms of protecting data. We have also parameters, Shamendra, to define how a privacy notice can be done. So Section 11, read with one of the schedules, will define the parameters for a privacy notice. So have a privacy notice, have a mechanism to basically manage it in a sensible, pragmatic, in a responsible manner. And of course, finally, to have a mechanism to respond to complaints if there are any. If you have some of those basics done,
right,
it should be okay.
Okay, so a privacy notice is something, there's software that will help you do that. It's not very complicated, but a responsible process, particularly for an SME, it can be overwhelming, I suppose, to think about it. Okay, what does that mean? Where do we start, right? If you're found in breach of these laws, are there consequences in terms of what sort of worst case consequences are we thinking about? assume there is there's somebody who's willing to challenge you on that.
So the worst case is if you are in violation, the person affected has a remedy to go before the new regulator that is proposed to be created and lodge a complaint. The regulator needs to have a hearing with both the complainant and the controller processor involved in the violation. And thereafter, what is perhaps important to remember is that the regulator cannot impose penalties immediately. There's a mechanism for which is called a soft law measure. There's a mechanism for the regulator to issue a directive in the first instance to a violating entity, depending on the nature and size of business, and of course give some compensation perhaps, but issue a directive to do a course correction. And in doing that directive, to get back to the tracks, so to say, the regulator can give a timeline, can look at the internal housekeeping measures, remedial measures that party has.
So it's the regulator is sort of quasi-judicial. It's aggrieved party does not need to go to court, which is an expensive, complicated thing. If you feel your personal data has been, your rights have been compromised, you don't have to think about going to court, so you go to the regulator.
Yeah. So there's a new regulator to be created for that purpose.
Okay. Jasmine, hey, I don't know whether you dropped off, but it's we have you back. Okay, before I come to you, I'd really like to sort of open things out to the floor. Also, I'd like to get some comments from some of the businesses here about how you're thinking about this. To Channa first.
So just one question. Now with technology, actually something that I came across. Now we are talking about SMEs in Sri Lanka, but what we found was once a colleague actually we were having a discussion on a certain technology, and then suddenly after one day, an advertisement appeared on that particular technology on the email of my colleague. And then we found out how that actually really came about, to find that Siri was active on his phone. And which means Siri is capturing what we are discussing physically and pushing that as an advertisement. I mean, isn't that a violation of privacy of discussion? How do you address that? I don't know. I mean, this is beyond, so I don't know, Jayant.
Okay, so is there a course somebody can take who suspects Apple is spying on them?
Yeah, so somebody like a tech guy can
answer
like
it.
him might have to figure out the pros and cons of the technicalities involved in the thing. But what is important, that question raises an important perspective, Shamendra, about the scope. What is the scope of this act?
Sure.
And I will let Sujit go into the technicalities of how it can be detected, right? On the scope, remember, this law is not only applicable to the school or the supermarket or the bank, telco that will be collecting our data. It would apply to even a foreign entity where our Sri Lankans or data subjects here have registered, and to whom goods and services are pushed from another country. So it would cover all the entities that were mentioned by the gentleman who asked the question. I think it was Channa, right, who asked the question. So in that case, Apple. So we have Google, Yahoo, Microsoft, Facebook, Twitter, all of them including Visa, Master, Diners, Amex. And it's no wonder that besides the 7 stakeholder consultations we had on this law, 32 written submissions were filed during the drafting process, and a lot of them were global tech companies who addressed clarifications to us because they were going to be regulated under this. So in effect, the future regulator would be able to open, in that example that Shanna gave, open an investigation and call for a clarification from Apple in the same way a European data protection regulator would be able to do. So in that context, Shamindra, you may have to go into a little bit about what kind of regulator we need to have. It's not going to be a government standalone agency that can function as a regulator. A regulator will have to be a very unique entity, and let's talk about it.
Right. Just to get also some basic stuff out of the way, this act is already law, but it is being, we are yet to appoint a regulator. We are yet to set up a regulatory authority. This act was passed into law in 2022, March 2022, and there is so usually when a law is passed, it's enforced fully, right? You cannot suggest that, okay, I didn't know that such a law existed. Is the approach different with this law, Sujit or Jayant? Yeah, go ahead, Jayant. Very quickly.
So Sujit will add to this because
Right.
they were all part of the process in the public consultation phase. This law is an act as of 9th March 2022.
Sure. Right.
From that day, from 19th March 2022, we have 18 months to 36 months window for operationalizing it.
Sure.
And before that time frame, the government has to set up the new regulator.
Correct.
So I think we have to manage our expectations in terms of enforcement. A new kid on the block, namely the new regulator, cannot go on a journey towards enforcing this in a full-blown fashion. There is a soft law approach using some administrative law tools we have built in here to enable the regulator to gradually implement it through sectoral guidelines. And the sectoral guidelines and rules cannot be drafted again alone. The regulator has to appoint advisory committees. Under Section 32, there is a separate scheme for that.
Okay.
So stage by stage, they'll have to do it. That's why I keep telling Shamindra to everybody, it's not up to me anymore to get it done. All of you, including the industry association, should perhaps take a lead.
So when the regulator does get around to drafting these sectoral guidelines, the regulator must talk to the affected industry and see.
Must. We have gone one step further beyond other regulatory regimes here. For the first time, we have introduced something called a public consultation process to be carried out before the rules are finally adopted and gazetted.
Correct. Jasmine, let me bring you in. You laid out the potential you laid out the landscape in Southeast Asia and to somewhat in Malaysia. One yes or no answer question: does Malaysia have a similar privacy law, data privacy law?
We do. Ours was made into law in 2012, and we are going through our third iteration now. And the youngest kid on the block, as far as personal data laws are concerned, is Indonesia, that just passed it in October 22nd. If I could just, okay, I will stop there if you have additional questions.
Yeah, so I want to understand from what you've seen in Southeast Asia, what were the challenges that businesses faced as these laws came about, and how did they sort of comply? Was it a difficult period? What was the approach, if anybody wants to know how to approach this?
I think we don't want MSMEs to feel the cost of compliance. And that is always a concern. And I want to call out an example that I'll start with Singapore. it's very interesting that Singapore actually wanted to make sure that it was a bit of a light lift for MSMEs in Singapore, and they started identifying companies and technology products that would ease the cost of compliance for the MSMEs. Similarly, they did the same thing for cybersecurity products, digital products that has built-in security measures. So that helped sort of break the cost of compliance, not so much in ensuring they're collecting the data and storing the data. So it was interesting that the government in Singapore and in Malaysia, the cloud was seen as a potential way to ensure that the cost of compliance is not, is not increased because you're having a data center or servers under your table. So with cloud, a lot of that cost was frayed, right? So that was one way that the government actually started encouraging MSMEs to adopt cloud so that they could not only reduce the cost but also reduce the cost of compliance. That I would call out as some of the best practices.
Right. Sujit, let me bring you in. You sort of drew a line around security and privacy, that the two go together, right? And it's going to be tough for companies because they have to now start thinking about these things seriously. So let's be very practical, right? Yeah, sure, you have cloud. I mean, everybody's got, some, at least Microsoft 365 kind of cloud or Google Cloud or something like that, right? It's not very expensive. But this law may require you to be more sensitive with how you use your data. So where do you start, particularly if you have data and not everybody in the company knows what to do with that data, how responsible to use that data?
Interesting question. I think it's a thought-provoking question. I guess everybody should be asking the same question, right? I mean, I would say the boards, the senior management, and everybody who is responsible in an organization should be asking this question. So some of my experiences have been, right, I mean, we started looking at GDPR way back in 2015-16, and it looked so massive. Where do we start? What do we do? Right now we have our own, right? And then when we are transacting with different countries, they would have their own. So we said, the best thing you could start with, ask yourself, what is that you need to do, or what is that information you need to have to deliver service? Right? For example, let's say, I think we have Zufar here, right? Yeah, right, PickMe. Why would PickMe need my wedding anniversary? Just an example. Right? If he's asking for that, then he has an additional responsibility to protect that data. Right?
So we have this mindset that, data is the new oil. So, if you have the wedding anniversary, let's keep it, right? Kind of like mindset. Yeah. I mean, should we sort of rethink that?
Definitely, we should start rethinking, right? I mean, in the past, people thought, okay, giving away, there's a raffle draw, give me the date of birth, give me the wedding anniversaries, and you think you win a prize. But what in essence they are doing is they're collecting a lot of data so that around that time they can productize and market their products, right? So send your wife a picture of the new ring or the bracelets or accessories, and then the next minute she's out there asking for your credit card, right? Right. So that's a business strategy, but today that can also cost them a lot in the sense that they got to now protect their data which they really don't need to collect. Right? So the question you need to ask is, are you collecting information? What you need to deliver that service? If you're collecting that, then how are you going to?
Should companies, how do you approach this? Because companies may have, now there's going to be a raffle draw, there's some business cards obviously in there, right? Somebody's going to take this and create an email list, potentially, right? Very dodgy thing to do under the current legal framework, right? However, companies will take the view that, hey, it's good to have this data, I can use this, let's put this in an Excel sheet, let's keep this, we can create this gigantic email base that we can someday use. Is that the wrong way to approach it?
I'm not sure I can give you a full answer for that. I would need help from Jayant and maybe from Jasmine as well, right? If you're just looking at the business card information, that is not linked to any transactions, right? You just have some data about somebody, that's it. But let's say if I were to go by the Uber experience, and if when the Uber account gets breached, it gives you a whole lot of data about your trips, where you were yesterday night, how long you've been there, right? So now you're bringing in additional data. So that gives rise to a different problem, right? So Jayanta, maybe you can help me answer that question.
So I think your question posed an interesting perspective based on what Sujit also said. In that example of putting a business card, we were not forced to do it. We did it voluntarily.
But just for the draw, we think.
No, I know. So does that tantamount to implied consent? And if you take the concept of consent envisaged both in the law and beyond, the new regulations that may be formulated, you may have a situation where, people are not going to be signing consent forms, but you might have a general set of principles defining implied and express consent for use beyond a draw, whether you might like to be notified beyond that purpose. So remember, this law is got a set of principles about purpose limitation and the principles of consent, performance pursuant to a contract. A lot of flexibilities are there, but I just want to qualify that by simply concluding. Implementing a new regime without constitutional rights to privacy requires a culture shift, which cannot be done alone. Europe took 20 odd years for GDPR. We have taken a softer approach to GDPR and borrowed from the APAC privacy framework as well. But just today, I'm pleased to say, the European Commission Data Protection Board and the European Union Cross-Border Data Flows Division are discussing with us how best to create a transit hub in Sri Lanka for channeling data from east to west. That's a level of discussion ongoing. It's up to the authorities concerned to take it and fly with it, because I think I want to call it quits and have a...
Jasmine, let me put this question to you. You told us about how in Malaysia and Singapore, governments stepped forward to help companies, particularly, I guess, the smaller companies, transition in, right? What, besides resources and knowledge, what were the problems that these companies faced and the governments thought it fit to help resolve or solve? Is it finance? Is it knowledge? Was there anything else in that mix?
I think a combination of things, right? Personal data protection laws, in a culture where we are, we are not, our culture doesn't say that we give consent to everything quite easily. Handing out our national IDs, from a cultural perspective, the government had to do a bit more to educate people to be aware about, just general public to be aware about their personal data. Most of us today do accept cookies without thinking of the consequences. Consent to a lot of things, and then you are wondering, how is it someone has my data? So it was a two-pronged strategy where, MSMEs who, especially during COVID, before, things got digitized, they were writing things on notebooks and keep leaving it open. which didn't work, and that's when the government decided that they needed to step in and ensure that the MSMEs particularly had a bit more hand-holding in ensuring that they understand and build in frameworks, which is more guideline because the law has been there, but compliance, especially for MSMEs, was a bit more harder. And I think over time, the transition that helped is three things. Number one, how do they subsidize some of these digital products? Digitalization of the MSMEs, built in some of the digitalization of MSMEs looked at privacy and cybersecurity by design. Number two, how do we skill up people in the organization? What kind of incentives can be given? What kind of grants can be given to key people in any organization to be trained so that each organization will have someone who has some basic privacy training. Thirdly, a lot of the SME grants by the government also considered companies that are able to articulate privacy practices. So those were the three things that actually sort of quickly gave them more stars. The MSMEs that had a robust privacy practice would get more stars, which means they would qualify for better grants, they would qualify for also banking loans. So those were some of the things that the government did.
Thank you. So there was, the government did give out grants to individual businesses to help with the transition in both Malaysia and Singapore?
Actually, across the region, MSME digitalization grant was a common factor across the region, if not globally. We see that. And then that little star for those who are a bit more conscious of privacy, but privacy and cybersecurity always comes in together because that is seen as a competitive advantage to also attract foreign direct investment.
Interesting times. So Sri Lanka is rather bankrupt now, so grants may be a tough thing to do, but it's interesting that governments in the region thought this was a great way to help digitalization. There's a question over there. Let's keep it very brief. We have only a few minutes to go.
Sure, thanks. My question is actually to Jasmine. Just to understand now, you said you're in the third generation, and the question number one is, does the data, not only the processors, also the storing entities are governed by the Malaysian Data Protection Regulation? And also, if so, has there been any action taken, any breaches by the data storing entities? You mentioned AWS, etc. And has there been any action taken or any fines during the period that the act was enforced? Thank you.
Thank you for the question. The only entity that is not covered by Malaysia's personal data protection law is the government. And therefore, we have not seen particularly breaches with public cloud. I want to be very clear. We have seen breaches, but those breaches were unfortunately, within government. And government is not covered. PDPA doesn't cover government.
Does Sri Lanka's law cover the government, Jayanta?
It covers both, and that's the challenge.
That's the challenge, right? Okay, Zulfa, go ahead.
So one of the questions we had in the morning was about taxes. You know, we had the central bank governor talking about taxes, and obviously a debate was, you know, why are the local companies taxed and the non-domicile international companies not being taxed? Would that, I'm just trying to see, though Jayanta did talk about it, but there seems to be less teeth for international companies that operate here that are non-domicile, right? You mentioned about a company being hacked. If it was an international company that was, the data was leaked, would Sri Lankan rules have any way to sort of reach out to those companies?
Yeah, excellent question, because it's more focused on equality and how to treat players, big, small, local, foreign, and whether we would have recourse to international remedies. And this is why Shamindra and Sujit, I think in our discussions in the past, the regulator having to implement an interoperable framework. It's there in the preamble of requiring them to be not working in isolation, requiring the new regulator to be interoperable and have a cross-border cooperative mechanism where our locals would have remedies elsewhere and vice versa. And on that question of equal player rights, what's important, as I said before, this law applies to local foreign entities equally. And we know that responsible players, of course we have Microsoft here represented, they are responsible like other big tech companies. They don't want to be seen in violation of any law. But the challenge in our law is not only of its application to local and foreign companies. The challenge in our law is that it applies equally strongly to government entities. And scaling up the ability of government entities and educating them, the need to adhere to minimum standards is going to be one of the biggest challenges for the next regulator.
You mentioned interoperable framework. Very, very briefly, without quoting the law, what does that mean, very briefly?
Well, the rules, guidelines done here should be compatible with a global standard.
Okay, right. Yes.
Yeah, so one question I think in terms of data protection, the purpose the data was collected is important, right? And for that purpose only an entity can use it. But the problem is, I think Shaminder brought about a visiting card. When you print a visiting card, the intention is to share that information with others. So you are giving a visiting card to somebody which has your email address, phone number, everything. So when you are doing that, how does the data protection act, how does it apply?
Fantastic question, because
there's a lot of thinking going into the raffle draw. Right? Okay, who's going to take the cards home?
It's actually the principle of consent, how it would operate within the framework of the schedules that link the lawful processing criteria. It's a bit complicated, but let me put it simply. If you give your card, you are implying consent for its use, right? Otherwise, you can opt not to share. I don't share my visiting cards now. Those with whom I like, I just share my email address, and I sometimes don't give my mobile number. So it's up to you and I to figure out what we want to do with our own data sets. But that said, if we are induced by a raffle or whatever, and we give it with the expectation that it is only used for the raffle and not beyond, then there is a legitimate ground to complain. So that gives rise to an interesting perspective, what Chan asked. The need for big, small, medium entities to look at their contractual cycles to define the purpose for which data is collected and is going to be used.
This thing is blinking, so we are out of time, right? I'll bring Zulfa. I'll put you on the spot just to get some background, right? You have a lot of data, right? You know where everybody's been, how long they've been there. You know Sujit's wedding anniversary, apparently. How does a company like yours, just to give the audience some perspective, start approaching? What do you need to do to change your ways of working to be compliant eventually with personal data protection?
I think the way we've approached it, obviously we are working with our legal team just to sort of make sure that we are compliant to the regulation. But obviously for us it's about not being able to identify people, right? So we don't carry any phone numbers, because there's a lot of data analytics that takes place. We have one of the largest data science teams in the country. So none of the data that they get is identifiable. So we don't know it is Sujit's or Jayanta or yourself. We just know people. We know that so many people have gone to such a location, and these are the kind of people, or this is how many people that take a ride from, say, Hilton, right? So it's never identifiable, if I may put it that way, and that's the approach we've taken. And when we share our data, it's never identifiable.
So they call this anonymizing the data.
Anonymize,
right?
that's the word.
Right.
Yes.
Now, for instance, if you wanted to advertise, if you wanted to run advertisements, hypothetically, right, then it's helpful, even if you don't identify somebody by say, identifier like a phone number or an email address, then you have to start targeting, right?
Yes.
Does that mean that you have to then, does that require you to have additional safeguards, or how does that work? Does that fit into your current framework?
It does. I mean, there is certainly those data that we look at. Obviously, it's very. I think we've a long way to go, because now, with all these restrictions that are now taking place for Facebook, for example, they're saying that companies that are closer to the source have better opportunities, which would be companies like us. So we are obviously trying to build on that. But obviously, for us, it's about understanding behaviors and being able to see whether we can value add in those behaviors, right? So, for example, if you are taking a ride in the morning, can we make sure that you have a vehicle close to your house, right? So these are some of the ways we try to improve experience on our platform.
Shamindra, can I add something?
Yeah,
to what
very briefly.
very briefly.
Yeah.
But I think from a platform perspective, they're taking everything within their might to address. Their challenge would be the ecosystem, the riders, right? Because the rider can tell who actually traveled in the previous ride, and even can, if you're smart enough, you can even solicit that number. I've done.
A couple of questions, we'll just take the last ones. We are out of time. Over here.
Thank you very much. Plenty of subjects that we went through and we learned. Ziam from Vensis Networks. Just want to ask to both of the panelists, hope everyone knows there is plenty of email grabber softwares out there. If you know the domain, you can easily download all the emails of the organizations. And if you go through the LinkedIn profile and you can search for the company, you know all the people who are working for the company. And if you search on their name on social network, you can get there all the birthdays and everything. So there are certain data that is already available in the public, whether you like it or not, it's there. So have we defined these are the data where it can go for public, and these are the data where it can be private data? It's one. Second, have we learned any lessons from the Optus data breach and the Medilabs data breach? So those government, they have taken regulatory actions, and do we have any sort of a solution for that if it's happened to us, our data breach? To both the panelists.
Very briefly, right? I mean, you spoke about LinkedIn and all that, right? I mean, again, I would say the law is very clear. If it is already published, if it's somewhere else, then there is no argument. I don't think we would spend time trying to debate, okay, that the place where it breached is from this place.
Can you just grab stuff like that and put it into your database?
No, again, legally, it is not right? Isn't it?
So whether it's previously public or privately hosted, if it is personal data, identifying individuals, that is what is important. Identifying and linking individuals, the banner you said, that individual concern has a remedy if there is a violation in the use. So when somebody put it up there for public use, I mean, if they have not masked it properly, then of course those may be possible defenses somebody can take in the event of an inquiry, that it was publicly available and that individual had not taken measures, but the individual would have a right to at least be told about the manner in which that individual's data is used, because here you have a whole new array of rights. This law is about rights. So individual rights can be exercised by a number of ways, even towards LinkedIn or any other published posting, requesting them to take it off or know what your data is. So number of remedies are available. I'll let Sujit take care of the breach. But in a breach, similar to what you mentioned, what is available in the law is a remedy for that company to notify the breach to the regulator that is available. And there's a possibility for data protection impact assessments to be carried out. And of course, the individuals impacted would have stronger remedies to go to a regulator for rectifying the damage. But calculating the damage is going to be a hard thing, because it all depends on the proportionality, and that would also mean the best practices that company has taken to protect. So if an entity has taken the best possible measures within its within its realm to look after the individual rights and protect the data, then the compensation can be minimized, right? So there are mechanisms like that available.
I'll ask each of you to wrap up. Also, just take a minute. If there's anything you want to address on that question, go ahead. Otherwise, can I ask you to start?
If there's anything, I'll take it offline with us. Right. Just one takeaway, right? Be conscious of the data you collect. And if you do collect, try and identify whether it is personally identifiable information, whether the information can be used to identify, locate, or even communicate. So I would probably put it into those three buckets. Can it identify a person, or can it help communicate with that person, or can it help locate that person? So try and understand what you're collecting and how you're going to use, and I think that's one takeaway for you.
Jasmine, may I come to you? Last thoughts, take a minute.
Sure. Thank you so much. Thank you for the opportunity. And I would like to address two things, and I'll go back to one of the questions that was raised. And I think Dr. Jayant has addressed it, but one of the things that you want to see as far as companies who are collecting data is the commitment to convey, to inform if there's a breach. There is a contractual commitment for us to inform if there's a breach from the time we know. So I think that is something that we, and that is not only in compliance of the contract, but also a lot of regulators have started putting that requirement, that notification of breach, it has to be informed. The data subject has to be informed. So that I particularly wanted to address, that we do provide in our contractual commitments. And as summary, the personal data protection journey is not that starts and ends with the law. There's a lot of awareness and a lot of education, and there's also a cultural shift. I think the regulator looks to enforce, the data scientists, the platform businesses look to monetize. I think there is an opportunity to actually turn this, and anonymized data can give you better products. I think at the end of the day, foundational to digital economy is data, and how best we protect as well as innovate and put in the right measures is most critical in ensuring that we balance between privacy and innovation. Thank you.
Thank you. Jayant, the last words.
Yeah. So thank you again for this panel, Shamindra, and for inviting us. But in terms of concluding thoughts, what I have to say is that we have the first law in South Asia of its kind. It's to be seen how we can evolve to a model to implement it in a manner so that the individual rights, which are very strong here, can be proportionately balanced with the mechanisms that and the best practices that an organization can adopt to secure and protect our rights. So balancing these two is going to be a challenge for a new regulator. I cannot predict how the new regulator will behave. It's up to each of our stakeholders, especially the industry associations represented here, to lobby and ensure that we have a state-of-the-art regulator with the right talent, not to go and take measures which will be like in a bull in a china shop approach, but guarded, soft, and then impose penalties along the way if needed. But keeping in mind, if you look at the fine print here, if the guidelines and the rules are done properly in a consultative process, a number of new business opportunities can be created out of this regime. And that was the original intent behind the formulation of this law, not to stifle innovation, it is to support digital economy and innovation and the future of our country. Thank you.
Right. So, Jayanta, the budget has already announced that it will fund the setting up of a regulator next year. That is what the budget says.
Yes. So, budget speech has a very positive statement about independent regulator being created in collaboration with the central bank, SEC, Insurance Board, and TRC. So, let's see how it will play out. There are strict guidelines on the selection of the board members. They have a guaranteed tenure. And Shamindra, one last point, under the regulatory regimes we have in this country, where the ministries can give directions, this has got a provision that has taken that out. So once the board is appointed and once a director general is selected on a competitive published criteria, ministry can't get involved in the operational aspects of the.
Okay, so the ball is also in your court, ladies and gentlemen, as data subjects or people with personal data. You have rights now. And also, if you're a business, you should be then potentially engaging this regulator about how that framework of regulations affecting your industry are going to be drafted. Thank you. Thank you to Jayanta. Thank you to Sujit. Thank you to Jasmine. Jasmine, thank you. It must be quite late there. So thank you for joining us. And that's a wrap. Thank you very much.